Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we delve into the latest news on privacy and data protection from all over the world. Today, we bring you in Canada together with Kristen Pennington from our law firm, McMillan LLP. Kristen is a partner and expert on privacy and data protection in the firm, and she supports and advises businesses in the application of the Canadian privacy law. In this regard, today we are going to discuss with Kristen about news that comes from the late fall of 2024, that is the one related to a decision from a Canadian court related to the application of privacy and data protection in the private sector. And this is very much related to a company that we know well, which is Clearview AI, because it's actually the response that the authority has given to a challenge made by Clearview AI against its previous position. So, Kristen, first of all, thank you for being with us. My first question to you would be, can you give us an overview on what we are talking about and what was this case leaning towards?
Yeah, absolutely. Thanks, Alessandro. So shortly before Christmas, the British Columbia Supreme Court, or BC, as we refer to it in Canada, issued findings in Clearview AI's challenge of an order that was made by the privacy regulator in the Canadian province of British Columbia. So as many listeners will likely already know, Clearview AI operates a facial recognition system that scraped publicly accessible images from social media and from other online platforms without obtaining individuals' consent, which it then converted into biometric identifiers. And Clearview sells software to law enforcement agencies as well as to private sector entities, which allows its customers to match faces to the images in Clearview's searchable biometric database. So way back in 2020, 4 of Canada's privacy regulators, including the regulator in BC, investigated Clearview AI, and they found that Clearview had contravened Canadian private sector privacy legislation. And when Clearview continued to collect and store images of Canadians, BC's privacy regulator eventually issued an order requiring Clearview to comply with the recommendations from the 2020 investigation report. And then Clearview challenged the regulator's order, and this is the court decision or the case that provides the results of that challenge. So that's how we got to where we are today.
Yeah. That's extremely interesting. And just to move on what the challenge of Clearview AI was based, so which was the key position of the company in this case.
Yeah, so Clearview argued that it's not subject to British Columbia's privacy legislation because it doesn't engage in any business activities within BC, and it has no employees, no offices, and no servers located in that province. However, this case is important because the court disagreed with Clearview's position and found that a business will be subject to BC's private sector privacy legislation if it has a real and substantial connection to the province. So the court then went on to find that Clearview, in fact, did have a real and substantial connection to British Columbia, in large part because it carried out marketing and it provided its services to entities in BC, including BC law enforcement. And also, Clearview collected, used, and disclosed personal information of individuals who themselves were located in BC. So it's also worth noting that the court suggested in passing that even if Clearview didn't market or provide its services in BC, the act of collecting, using, and disclosing personal information of individuals in BC that is gathered from the internet, that alone would have created a sufficient connection to British Columbia for its legislation to apply. So that's important because it could potentially sweep in a number of organizations that might not otherwise meet the real and substantial connection test, but may, based on this commentary from the court, be found to be subject to BC's legislation anyway.
Yeah, that's extremely interesting, Chris, and thanks a lot. And maybe we can extrapolate some of the key lesson learned for businesses, in particular for international businesses that could have been in a similar position to the one of Clearview AI.
Absolutely. So this particular decision from the BC court reinforces existing case law from Canada, indicating that Canadian privacy laws can indeed apply to organizations that are outside of the country or even outside of the relevant province. So the key takeaway here is that your business doesn't necessarily need to have employees or a premises in Canada or even in a given province in order to be subject to Canadian privacy legislation. So a key action item for organizations both throughout Canada but also worldwide is to consider the application of this real and substantial connection test and evaluate whether your activities are subject to, and if the answer is yes, compliant with Canada's privacy statutes. But going a bit further, I think the case also underscores the risks of not complying with Canadian privacy statutes, which can be pretty significant. So, the order that the court upheld from the BC regulator actually required Clearview AI to stop offering its facial recognition services in BC and also to make best efforts to stop collecting, using, or disclosing images and facial recognition data of individuals in BC without their consent, and to delete the previously collected images and facial recognition data that was collected from individuals in BC without their consent. So as you can imagine, I mean, the repercussions of being effectively prohibited from offering your services in an entire province, but also having to purge a massive amount of data could be pretty devastating for a business. So I think, in addition to the jurisdictional issue that the case addresses, it also really does underscore that the consequences of not complying with Canadian privacy laws can be pretty serious.
That's extremely useful, and it brings me to another question that is still very, very practical, meaning that we've been providing a lot of guidance in relation to the application of British Columbia private sector in the privacy legislation, but in general, I believe there is a lot that we can learn also under a broader perspective.
Yeah, absolutely. I mean, the case I think also serves as a really important cautionary tale about ensuring that your organization has a lawful basis to collect, use, and disclose personal information, particularly where that information is publicly accessible. So the court dismissed Clearview's position that it didn't require individuals' consent to collect, use, and disclose their information because it was freely available on public websites, and therefore that information was publicly available and consent wasn't required. And it's true that BC's private sector privacy legislation does say that businesses don't need consent to collect, use, and disclose publications that are available to the public, but it's construed very narrowly. So it covers things like newspapers, books, and magazines. It hasn't really kept up with the times. And so that narrow consent exception doesn't apply to all content that's posted, for example, on public blogs or on public social media profiles or other public websites. So it's an important reminder that, indiscriminate data scraping, even of information that is publicly accessible, is really a no-go under Canadian privacy legislation.
Thanks a lot, Kristen. And I think that, data scraping is another relevant topic, that we need to keep in mind, not just for Canada, but also by many other jurisdictions. So it's very interesting to see these specific case and the outcomes that it can open up. I would like to thank you very much for being with us today. It's been extremely interesting to know more about this case in Canada and specifically in British Columbia. I would like to thank all the McMillan team, as always, for being with us and for supporting us with those updates, and our audience for being with us also today. So I very much look forward to see you and all our listeners at the next Privacy Espresso. So thanks a lot for your time, and see you to the next episode.